I'll open the public hearing for resolution number 110424, resolution enacting an interim application process for telecommunication facilities. This time I'll open the public hearing. If you wish to address the body, please come to the microphone, identify yourself, give us your address, and I'd ask you to limit your comments to 2 to 3 minutes, and we'll move forward for this public hearing. So, is anyone wishing to address this body on resolution 110424?
Yes, sir. Thank you, Mr. Chairman, members of the Commission. My name's Nathan Ridley. I work with the law firm Bolt Cummings, Connors & Berry in Nashville.
Say that one more time. Nathan
Ridley, R-I-D-L-E-Y.
Thank you, sir.
And my address at the law office is 414 Union Street, Suite 1600, and that's in Nashville, Tennessee. Zip code's 37219.
Thank you, sir.
Once again, Mr. Chairman, members of the Commission, it's my pleasure to be here before you this evening. Our firm represents Crown Castle International. The public hearing tonight permits us to express our concerns over this pending resolution. Crown, just to give you a little bit of background, is a leading independent owner and operator of shared wireless infrastructures, including an extensive network of towers throughout the United States. The core business involves the engineering, deployment, ownership, operation, and leasing of shared wireless communication sites. Nearly every major wireless carrier is a tenant of sites that are owned or managed by Crown. Those tenants include, for example, Verizon Wireless, Singular, T-Mobile, Nextel, Sprint PCS, AT&T Wireless, and Cricket, as well as other state and federal government agencies and broadband data service providers. The United States operations have regional district offices, including a district office here in Williamson County with about 11 employees out on Mallory Station Road in Franklin. We own and operate 21 towers here in Williamson County, and each of those towers has an average of 3 antennas co-located on that single tower, for a total of about 63 separate antennas on only 21 towers. We're here tonight to express our concerns over this resolution, sponsored by Commissioners Barnwell, Davis, Mills, and Brockman. First, I'd like for you to look at the Rockingham County experience from North Carolina. I would hope before you go too far down this road, you'd speak with a fellow named Thomas Robinson, who's the county manager for Rockingham County. It's a little county, not unlike Williamson County, that's just north of Greensboro, North Carolina. Rockingham County in the past has had a Center for Municipal Solutions client, and they now state in a letter that I have from Mr. Robinson that they're modifying their ordinance to become more streamlined and more user-friendly. They're lowering their application fees. They're developing a means to own and market wireless telecom sites. And they're completing a comprehensive land use and development plans to identify areas that are suitable for infrastructure improvements. And they're also looking at their E911 service capacity. Another item, I'd like for you to take a look, if you get a chance, at the American Planning Association. It's very unusual for me to stand here and recommend that a governing body look at the American Planning Association recommendation, but I want to bring to your attention that Williamson County is not alone in this endeavor. The APA has just organized the first in a series of telecommunications forums focused on the public and private planning profession and the telecom industry. Officers from my client look forward to working with other professional planners from across the country in addressing these issues. But now let's get to the practical effects of the resolution that's pending before you tonight, specifically looking at the text of Resolution 11-4-24. This resolution is touted as one of having no risk and no expense to Williamson County. The resolution does, however, impose an $8,500 application deposit for each tower. The resolution makes absolutely no distinction between new tower sites and co-locations. Presumably, to decrease the number of towers, you'd want to have a lower fee and a shorter time frame for an approval of a co-location on a site that's already in existence. On the other hand, this resolution, it says it's not a prohibition by its very terms. The very first sentence says this is not a prohibition, it's not an exclusion, but oh, by the way, you have to comply with the terms of text that we're going to write in the future. I don't know how to recommend to my client to comply with that standard. Another of our concerns is the approach taken through your 3-year contract that was entered into on July 22nd and subsequently amended on August the 17th by the county mayor, Mr. Rogers Anderson. The contract with this New York entity entitled Center for Municipal Solutions has no responsibility and no accountability. First, the contractor's hourly rate's $200 an hour. For travel time, they graciously lower it to $100. Your engineer, Mr. Qualls, who's here tonight, is located in northern Alabama. Every time he comes to visit Williamson County, the meter starts to run. Secondly, the contract has no upper limit. Our experience has been with this sort of contract that it's an evergreen retainer. When I say that, I mean when it goes below a certain amount, the telecom company is going to be required to renew that deposit to keep it at the balance established by your contractor. Who for the county will have oversight over the implementation of this contract? Contract says expenses must have documentation, but if they do not, the county will still pay the expenses. Do the expenses cover chartered air flights? Do the expenses cover first-class air travel? Do the expenses cover limousine travel? Wonder if the expenses even cover a dinner at the Wild Iris down in Brentwood. Maybe the most disturbing portion of the contract may be the concern with lighted towers. I've talked with several of you, and I understand that. The Federal Aviation Administration requires by regulation that any tower over 200 feet in height to be lighted. Neither the Center for Municipal Solutions nor Crown Castle Communication can do anything about that. Our concern is that your contractor may well promise this county that there will be no more lighted towers in the county. But in so doing, the county will have more towers. Oddly enough, your contractor is compensated on the basis of the number of towers. While your contract's very specific that the county will have no exposure for any expenses, if an issue develops that cannot be resolved, I can promise you the result of that litigation will be styled Telecom Company versus Williamson County. It won't be versus the Center for Municipal Solutions. Let me conclude with just a couple of points. Thank you, Mr. Chairman. Under Tennessee state law, each county in Tennessee has the power to impose a fee for the review of an application for a permit, but that fee must, and I repeat, must bear a reasonable relationship to the services rendered by the county. Under the approach taken in this resolution, you've imposed an $8,500 fee for a service that presently costs one of our applicants about $700 or $900. Therefore, you've delegated to your contractor this power that's somewhat mysterious. Respectfully, in conclusion, I know my time is running short, and once again, I thank you for hearing me out. We would ask that you refer this matter to the Planning Commission. It's very interesting tonight as I listen to you. We've bragged, there's been a full hearing and explanation and workshops and meeting after meeting after meeting. We welcome those meetings in this process. We first learned of this just a few weeks ago. I understand it was on the Planning Commission in September, just about 6 weeks ago now. We would welcome the opportunity to work with you and your staff.
Thank you.
Thank you, sir.
I'm Doug Vincent. I work for Singular Wireless. I'm an engineer. I'm not a lawyer. We're here as part of my, to represent my company. We're a resident of Williamson County, have been for over 8 years. We have, between Singular Wireless and our parent company, Bell South, over 500 employees throughout the county. My company has very serious concerns about the interim resolution. We only found out about it about 2 weeks ago. We have not yet had a chance to have our attorneys and management fully evaluate it. What we have done is written a letter to the commission that I would like to hand out now.
If you'd bring it to the chair, please.
Bring it to the chair. Sure. As I stated, I'm not an attorney. I'm an engineer with Singular Wireless, and I hope this letter provides a certain starting point for further research by all parties concerned prior to a vote on this resolution. In short, the interim resolution would create a system of zoning regulations of wireless communications facilities called cell towers that would be different and far more erroneous than costly than obtaining approval by any other comparable land use. I have no doubt that it will be a barrier to improved wireless service within Williamson County if this is adopted. We do not see any good basis for treating wireless industry so different from other businesses, particularly when we are licensed by the FCC to provide service. Singular has worked cooperatively with many other cities and counties throughout Tennessee, including Brentwood, Davison, Knox County, Shelby County, City of Germantown. All of those that I just mentioned have very comprehensive zoning regulations for towers, and we've worked with each one of them, and would be glad to work with this county also. This is a complex area involving legitimate regulatory concerns with industry, between the industry, the zoning officials, and the public itself, working together for relevant considerations to be fairly addressed. We would welcome the opportunity to have a chance for some real participation in such an effort. We would ask this board to take a careful look at what is being advocated tonight and the background of this ordinance in other communities. The Center for Municipal Solutions and associated entities under the umbrella of Richard Comi has proposed this ordinance system to many local governments. There has been a litigation over the validity of these ordinances. We ask that you take the time to contact the local governments that were involved in such litigation and ask if they would still support a Comi-type ordinance. We're asking for you to get all of the relevant information and decide this for yourselves. As a county resident and a manager of Singular Wireless, I request that this commission table this vote on the interim resolution and provide a subsequent period of investigation and further hearings so that a thorough comments may be received and you have a chance to learn more about the experience of other communities with the Comi ordinance system. I assure you that if you schedule a further hearing prior to voting on this resolution, that Singular will provide the Commission with the best information that may be obtained on the Comi ordinance systems and the experience of other local municipalities. Thank you for allowing me to take the opportunity to speak with you this evening, and I look forward to working with you.
Thank you, Mr. Vincent. Next.
Mr. Chairman, my name's Andy Rotenstrike. If I would, I'd like to give you my card.
Spell that, Andy.
Because I have trouble with this all the time, so here you go.
Give the clerk one if you would, please, sir, so that she can have this accurately reflected.
My name is Andy Rotenstrike. I'm an attorney with the law firm of Haskell, Slaughter, Young, and Redeker, based out of Birmingham. I'm here on behalf of Verizon Wireless, but before I make my initial comments to you, I wanted you to know that not only is Verizon Wireless and Singular Wireless represented here, but you have several other wireless carriers that are here also. You have representatives from Nextel, you have representatives from Cricket Communications, you have a representative from T-Mobile. Are there any others? Many of those representatives actually live in Williamson County also. Let's talk a minute about this proposed resolution if we could. What you've got before you with this contract that your mayor signed with the Center for Municipal Solutions is a money-making program. However, the only person that is going to make money in this venture is the people working for the Center for Municipal Solutions. You have the capability in-house to handle all of the issues that come up with regard to regulating wireless telecommunications. Even if you don't feel that you can rely on those folks, there are many other companies that can handle your concerns besides the Center for Municipal Solutions. And many of those companies are not located in New York. They're in fact located right here in Williamson County. If you pass this resolution that is being proposed tonight, for the next 6 months, the Center for Municipal Solutions and Mr. Monroe and Mr. Qualls will have a monopoly on this work. If you pass this resolution for the next 6 months, the county gets nothing. If you pass this resolution for the next 6 months, the carriers get nothing except increased fees for the same opportunity to run their business. If you want to change your ordinance, that is wonderful, and we welcome the opportunity to work with you. We would be happy to be involved in that process. We can provide insight based upon the experience of dealing with the same issues that you deal with. We work with counties and cities all over the country in order to come up with an ordinance that works for the county or the city, for the carriers, the ones trying to provide you with cell phone coverage, and for the constituents of each county and city. This resolution that is proposed tonight only benefits the Center for Municipal Solutions. There was a case, a lawsuit filed by Nextel Communications against the city of Mount Vernon, New York. It was a case similar to what the issue is here. The Center for Municipal Solutions had been hired by the city of Mount Vernon, New York. Nextel Communications sued the city. On November 25th of 2003, U.S. District Judge Stephen Robinson wrote an opinion in this case. I want to read to you a couple of lines from that opinion. This is the U.S. District Judge in New York speaking. It is hereby ordered that to the extent the city finds it necessary to retain a consultant in connection with Nextel's applications, such consultant shall be a licensed professional engineer selected by the city's reasonable discretion. Provided, however, in no event shall the licensed professional engineer be affiliated with the city's current consultant, Richard Comi. Mr. Comi is a principal in the Center for Municipal Solutions. As Nathan indicated to you, let's plan some work sessions. Let's create an ordinance together. We can help you do that. We can address the concerns that you have. Let's create an ordinance that accomplishes the county's desires, yet works for the industry and for the constituents, not just for the Center for Municipal Solutions. This resolution is not necessary. Your existing ordinance is very functional and should continue to work just fine until a new ordinance can be drafted if you so choose. This resolution that is being proposed tonight does not accomplish what you want to accomplish. It only accomplishes what the Center for Municipal Solution wants. Thank you very much.
Thank you, sir. Anyone else wishing to? Here we go. Thank you.
Mr. Chairman, members of the commission, my name is Ross Kaufman. I'm an independent site acquisition agent. I'm the sort of fellow who makes the applications for zoning approval here in Williamson County and other counties around the mid-state. My address is Post Office Box 120181, Nashville, Tennessee 37212. I don't want to tread over some of the ground that's already been discussed with you here this evening. So what I will try to say from my perspective, as looking at this as a planning process, it appears that by entering into a contract with a consultant who had a sort of one-size-fits-all solution for a planning process, the county has allowed a set of private consultants who stand to benefit to hijack the zoning ordinance and this planning process for Williamson County. When this first came up, I attended the Planning Commission meeting and I spoke against it. At the time, I compared it, and I would ask you all to compare it to the process that the Stormwater Board went through, and you all went through and revising your stormwater provisions, where you had a series of meetings with stakeholders. There's a whole host of people here from the wireless industry who would like an opportunity to sit down and work with the planning staff and the Planning Commission to draft an ordinance that meets your concerns and also works with the wireless industry while not providing a windfall for private contractors. If you look at the specific terms of the ordinance before you tonight, it really is very vague as to what it accomplished. It says there's going to be a 6-month application, 6-month interim period where the ordinance is going to be reviewed, which is fine. It has a very fuzzy provision that says that all applications that are filed during this period will be subject to whatever rules are passed in the future, which is sort of very problematic, and nobody knows what that means. And in fact, staff has been telling people over the counter that that means that no building permits will be issued during this 6-month period while the regulations are being sorted out. But in the meantime, and the only thing that the ordinance truly accomplishes is it establishes an $8,500 escrow account to pay for private consulting fees. Private consulting fees for which there is no new ordinance that calls for those consulting fees, no oversight, no regulation in terms of how that money is to be spent or who it's to be spent for. And it's all to be spent per your contract that you signed this summer with your consultant, who is supposed to be helping you rewrite your zoning ordinance as it concerns telecommunications facilities. Just to finish up here, I've done a little bit of research on the available public records that I could find about the Center for Municipal Solutions, trying to find out who these people are. They're a group of telecommunications people and engineers. They, on their website, don't seem to list anybody who has any real planning background, and they don't seem to be registered as a corporation in the state of New York. Your contract with them is signed, the Center for Municipal Solutions, but it doesn't say whether it's a company or LLC or what sort of entity it is. So as the industry, it's sort of hard to know who we're going to be paying these fees to when we make this $8,500 deposit. And of course, as we've mentioned, there's no real accounting for how that money is to be spent. In addition, just out of curiosity, I checked with the Tennessee Corporations Committee, Secretary of State's website, and as of 3 days ago, the Center for Municipal Solutions was not registered with them. Neither was Qualls Engineering, who is the Alabama engineer who is listed as their Tennessee representative, nor Monroe Telecom Associations or Comi Telecommunication Services, who are other affiliated entities that make up this Center for Municipal Solutions. So I would ask, along with the others here tonight, that you table this motion or defer it, allow more information to come forward, allow your planning staff to sit down with the wireless industry and other stakeholders and come up with a more rational ordinance that better suits the needs of Williamson County. Thank you.
Thank you, Mr. Kaufman. Next. Anybody else wishing to address the body? Mr. Sanders?
Mr. Chairman, members of the commission, thank you for having us on and looking at this item. I'm Lee Sanders, and I am the Codes Compliance Director for Williamson County. And one of my duties is to work with the Board of Zoning Appeals. In 1988, our county here adopted a comprehensive zoning ordinance, and it included in it at that time how to permit communication towers, communication facilities. And we went through a period of only permitting 4 or 5 over the next probably 8 years.
In 1996, when the Federal Communication Act approved numerous licensing for cellular services across this country, the pressure definitely increased. We got together, the Board of Zoning Appeals members and planning members at that time, and upgraded our zoning ordinance in relation to communication facilities. And they have worked fairly well, and I have been told that they are at least as good as any in the state of Tennessee. That application process has, since 1996, included the putting together of site plans and providing to us some radio frequency engineered propagation studies, and the planning for the site, or show us where the access is and the electrical access, and of course that process then moved, after going through staff for those preliminary procedures and preliminary work on each site, then goes to the Board of Zoning Appeals under a special use permit review. And of course, in the course of time since 1988, we have looked at approximately 50 of these type of sites. Some of them, as noted earlier, required lights. Anything in Williamson County that is 200 feet tall, and this may be state, federal, I don't know, but the federal aviation requires that a tower or structure of 200 feet tall be lit, anything above it. And if you're in the pathway, the flight path of Berry Field, Nashville, it goes shorter than that to require lights. And that has been one of the most brought out issues in the public hearings that we've had regarding communication towers themselves, is the impact that those lights and that structure has, especially on a rural skyline. And we had hoped now to upgrade our ordinance again at this time. And this process started, I sort of started working with it, the thought of back in about March, and talked to county attorneys and the county mayor and others in the possibility of doing an upgrade to our zoning ordinance. And we did put out a request for qualifications through our finance department office. I know I gave them 2 different names of companies to contact, and Mr. Coleman's office sent out notices to wherever they put these notices at. I'm not sure, but it's their standard procedure for notification. And we got no response other than the two companies that I had given them the names of. I knew of the company that did Brentwood's wireless plan, their company located in California. And I knew of the Center for Municipal Solutions. And I had logged into their website and read some of their information, and have worked with some of their personnel when their personnel worked for private companies, private cellular companies. And in sending them a request for qualifications, we got the request back from both that company as well as the company that did Brentwood's program. And we asked them if they would help us in reviewing and creating a new ordinance, and what kind of program would they work with us on. And they have a program that cost the county nothing. It makes development pay for itself. It gives the county staff that time back that we spend with each one of these carriers that you've seen march up here tonight. We deal with them at staff level for the permitting process that we currently have in place, and we spend many hours with these people trying to get their applications squared away so that they can proceed with the permitting process. What we have tonight in front of you is an interim ordinance. It is an interim application process. It is the forerunner to what these people have been asking about, which is a permanent tower or telecommunications facility ordinance. And it will go through the public process, and that's what will lie in store for us through this application procedure. Now,
Lee, I might cut you off. As you're our employee, we may bring you back during the discussion of the resolution, but this is the public hearing, and I'm going to be fair, so your time is up.
thank you.
Anyone else that wishes to participate in the public hearing, please come forward. Identify yourself, please.
Thank you, Mr. Chairman. My name is Rusty Monroe. I'm one of the co-owners of the Center for Municipal Solutions, and Mr. Sanders asked me to take just a couple of minutes and address a couple of points. This hearing has taken a decidedly different direction than I had anticipated. I'm going to very quickly tell you right up front. Number one, I want to address a couple of comments that were made as regards litigation. Number one, whether the county chooses to adopt or not adopt anything that we help it with, of course, that is the county's prerogative. The litigation that Mr. Rodenstrike referred to, I was really very disappointed to hear his comments, because the judge expressly issued a subsequent opinion that Mr. Rodenstrike is well aware of in writing, stating that he in no way intended to question or discredit the qualifications, quality, or ability of Mr. Comi, who was the witness at the time. The judge even went so far as to say, and this is almost unheard of, anyone who would like to clarify this is free to call him, and he's issued, again, a subsequent opinion to that matter. The issue was simply the judge wanted a third party. There was an irreconcilable difference of opinions, and the judge wanted a third party's opinion. So I would ask you to, I'd be more than happy to provide that letter. I think that was a rather disingenuous comment. Very quickly, we are not here to in any way talk the county into or out of anything. We responded to a request for qualifications, as Mr. Sanders explained. The planning department decided that it needed to revise its regulations. We were asked about the need to implement a moratorium. We suggested that this whole approach should be a win-win situation. County should win, the industry should win. And that if the county were to adopt a moratorium, the industry is not helped by that. The public is not helped by that. Service is slowed down. The county is not helped by that, if only from an economic development perspective. This is an alternative that's been adopted by hundreds of communities around the nation, and it's simply an alternative to a moratorium. It doesn't stop the submission of any application process. It's intended, as I said, to create a win-win scenario, since from the industry's perspective, time is the issue. In this area, for every day that they are not up and operating, they are going to be giving up roughly $3,000 per carrier, per site, per day, or effectively $90,000 to $100,000 in revenue per month. This is intended to prevent that situation, so they can. Again, we are not here to try and talk the county into or out of anything. Our job is merely to assist the staff in the county in its deliberations as regards revising or updating its regulations, and to enable the county to make informed policy decisions, knowing its options and the positives and negatives of each of those options. There is no right or wrong decision, only an informed decision. That's about as synoptic as I can be. I'd be more than happy to answer any questions if anybody were to have any. But I think that's probably a good place to stop.
Thank you,
Thank
Mr.
you.
Monroe.
Mr. Chairman, Commissioners, my name is Hunter Stewart. I live at 229 Warwick Park Lane in Franklin, Tennessee, and I am an employee of Crown Castle USA, or Crown Castle International. We do have offices here in the Franklin area and Cool Springs. I somewhat feel like the horse thief that was caught and was being tarred and feathered, And when he asked if he had any comments, and he said, if it weren't for the honor of the thing, I think I'd have my feelings hurt. And that's kind of the way I feel standing up here. Listen to Mr. Perry. Our company, as we said, is an international firm. We have dealt with Mr. Perry, not myself personally or my office, but our adjunct offices in Indiana, New York, North Carolina, Alabama, and we're seeing exorbitant time delays. What we see should take a 30-day staff internal review has literally taken months for him or the organization CMS to render approvals. Sprint has an application pending in Indiana now that they've been well over a year, $20,000, and have yet to receive a recommendation to be put before staff to get approval on their proposed co-location. I would submit to you that you have qualified staff or qualified individuals here in the state of Tennessee. Check with Knox County, where Mr. Larry Perry charges a flat rate of $1,500 and gives a promise that his recommendation will be given to the staff before the item is heard on the next agenda meeting. We've worked with Mr. Perry. He's countered what my clients need. We've worked with him and worked with his proposals and recommendations, came back with a win-win situation for both the carrier and the county. Why look to out-of-state firms to do what we've got here in our backyard? What the industry needs is time-specific deadlines. As Mr. Perry said, it is money. Time is money to our carriers. But also it's the cost. We're shooting at a moving target and we have no true definition of what that cost will be. Look again to Knox County and ask Mr. Perry, how can he charge a flat rate of $1,500 and give a product within 30 days? Look at Barge Wagner Summer & Cannons, an engineering firm here in the state of Tennessee with offices in Nashville, residents of Williamson County that can provide the structural support or the structural integrity reviews that you need. They have the staff. They're a local Tennessee company. Why go to New York? Why go to Alabama? Why go to affiliates when you've got the resources here in the county? Pay attention to the industry needs. Let us give you some feedback. Please give us a deferral on this issue. Table the motion. Let us work with you and for you, and we can come up with something that's good for the county, good for my industry, good for my carrier's industry, and I think we'll have a win-win situation. Thank you, sir.
Thank you.
My name is Patrick Bardone. I reside at 1036 McKay's Court, Brentwood, Tennessee.
Spell your last name, Patrick.
B-A-R-D-O-N-E.
Thank you.
I'm also a representative of Nextel Communications. And I am here tonight, like other members of the wireless community have discussed, in favor of voting against this interim policy. I ask that you consider this, consider the committee, the commission that others have spoke about tonight. Let us all work with members of the public, members of your commission, and members of any engineering firms that you may have in the area. And I won't take up any more time, because a lot of things have been discussed tonight that I agree with, and I ask that you consider tabling this evening.
Thank you, sir.
Thank you.
Anyone else? Anyone else wishing to address Resolution 110424? Public hearing is closed. This time we'll entertain Resolution 110424, resolution enacting an interim application process for telecommunication facilities. Commissioner Moon?
Move for approval.
Let's see, I'm sorry, Commissioner Barnwell, Davis, Mills, and Brockman. Second, Commissioner Davis. Planning Commission report, Commissioner Moon.
6-4, 2 against.
Tax Study Committee.
4-4, 0 against.
Thank you. Budget Committee.
Budget Committee recommend approval 4 for, 1 abstain.
Okay, explanation. Let me go. Okay, just let me get Commissioner Bivens first, and I'll come to you, Commissioner Barnwell. Commissioner Bivens.
Thank you, Mr. Chairman. Mr. Chairman, members of the Commission, I need to declare a conflict of interest on this resolution. As a result, I will be abstaining from participating in any matter in the consideration of this resolution, and I will be abstaining on all votes involving this matter.
Thank you, sir. Okay, let's, Commissioner Hancock, yeah, let me go to Barnwell, and then we'll come back. Let's get it on the floor in introduction, and as you're one of the sponsors, I'll let the sponsors address it, and then we'll go to discussion. Commissioner Barnwell.
Yes, I'm going to mostly defer this to our legal staff as to the explanation of it. I agree with it. I think we ought to bring in these people that have been talking to us this evening in this 6-month period to help us come up with these new regulations. But I will defer to Bobby and to Lee.
Commissioner Davis.
My only comment is that this is an interim proposal. There is still time for consideration. This does not change any ordinances at this time. Our staff came forward with a proposal saying that they do not have the technical expertise to fully evaluate one of these applications, and frankly can be bamboozled if that was the intention of a cell tower company on the height of a tower and where it should be placed. And that does impact the residents of Williamson County. So I would urge that we do move forward on this tonight.
Thank you. Commissioner Mills. Any comments?
No.
Thank you. Commissioner Brockman.
I would also urge for support of this resolution tonight. I think we're looking for a cost-effective and professional procedure for locating towers. We need an ordinance that is going to reflect the importance of prioritizing locations, securing appropriate fees, considering the aesthetics. Sometimes you need a consultant and an expert to help you review and doing the analysis. And I think this resolution gives a fair process for that period of time to look at it and see how we can come up with something that's more effective, more professional.
Commissioner Hancock.
Mr. Chairman, Commissioners, I got a couple of questions, one question in particular. How urgent is this? Is there something that, some reason that we need to move forward with this right now? If so, I'd like to hear what that is when I get through my remarks. I haven't seen this much interest circling around in a long, long time, so there's got to be some dollars on the table somewhere for somebody.
Mr. Sanders, would you come forward?
And I haven't seen, this much interest in anything like this we've done for quite a while. So what's the urgency? Do we need to move forward right now?
Lee, could you address that question, please?
We are, and this what I learned and started me on this road back in about March or April, is that the second round or third round of money, I forget which it is, phase 2 or phase 3 that these communication facilities people call it, got their money for build out, and we, of course, we saw one tower application last month at the Board of Zoning Appeals. We've got one lined up, a 270-foot tower lined up for Bending Chestnut Road on the Board of Zoning Appeals for this next Thursday night. We've got two 400-foot towers that are in process, and another 315-foot tower that is in process. And all of these people that have made applications, I talked to them in May and learned about about five of these facilities that were in the works at that time, and they have moved forward with the applications for 2 of them. I told all of them involved that I would take applications up until 4:30 this afternoon under the current regulations, so that, for fair shake, if the board votes tonight to change that ordinance, then we would move into the new ordinance phase starting in the morning. If not, we've continued taking applications for these up until, like I say, late this afternoon. But those are facilities that have come forward while this process has been in the works, and that's the reason their interest is high on it, John.
Thank you, Mr. Hancock. Commissioner Moon.
Mr. Chairman, before I get to my remarks, I find it ironic that on the one hand they complain that
the consultant is a corporation of New York, and then on the other hand, they quote a U.S. district judge in New York as supporting their authority. It seems to me you can't have it both ways. When an application for a tower or use on a tower is made, the consultant comes up from Huntsville, drives his car, he doesn't come in a limousine, nor does he fly first class, and he gives the staff his informed engineering opinion. Is the site stable? Is there any specific modifications that needs to be reinforced? Can they piggyback on another tower? It was mentioned that the county gets nothing. Well, the county gets the advice of a consultant whose dog is not in the fight. And it said it only benefits the consultant. It benefits the county. Well, I'm going to make an amendment to this resolution because it was mentioned that there is no accounting. The county spends many, many hours on every application. Of the $8,500, the consultant's fee is deducted, the balance goes back to the applicant, and the time that the county spends in reviewing this, not only by Mr. Sanders, but by Joe Horn, Greg Langlear, Floyd Heflin, the county does not get reimbursed for its cost. You can't have an amendment that would use this as a way to raise revenue. That's illegal. But we can make growth pay for itself, and we need to have an $8,500 flat fee, which is legal, to cover the county's cost. And I would amend this resolution that the deposit be retained by the county. Finally, I just mentioned this is just a 6-month process. During the 6 months, the representatives of the industry can come and communicate and collaborate. This has been on the books from the Planning Commission 2 months ago. We only heard from one fellow from their side. Now there are a lot more coming in. I welcome them to come in, but during the next 6 months, we need some regulation, and we need to cover our cost in the matter.
Is that a motion to amend, Mr. Moon?
Yes, sir.
Is there a second? Okay. The motion to amend is that the motion by Commissioner Moon is that the $8,500 be set as a flat fee, your words. And that's the motion that's made. And the second is made by Commissioner Hancock. And I guess my question would be from the chair, looking at the way this is laid out, it currently would pay any unexpended balance back. If I could have our council here share with us any comments on the legality of this amendment.
Mr. Chairman, the only authority that could say whether this fee is reasonably related to the expenses would be a court of law. However, because we don't have any records to say that there are expenses that are going to justify an $8,500 fee, then I can't recommend that amendment be made. Basically, what's going to happen is you're saying you have a fee for $8,500, and there are records out there that are going to support the reason for that fee. It has to be reasonably related to it. I don't think we have that information in front of us, and my opinion would not to be in support of that.
Commissioner Moon?
Mr. Chairman, I totally disagree with that. I'd call Mr. Sanders up and let him tell us approximately how many hours everyone on the 4th floor spends on an application.
I've tried to put together that number, and I'd say the average is 30 hours of total staff time spent.
Okay, Mr. Sanders, what's the average cost that the consultant charges per review of application?
Their time is based at $200 an hour and $100 for travel time. The time that they spend on their application, I expect to be less than the 30 hours that we spend, but I don't know.
Do you have a figure that's average?
No, sir, I don't.
Right. If we say even $2,500, is that reasonable?
That's reasonable.
That would leave $6,000 for 30 hours of work. There is a reasonable relation, and I think council will tell you if there's a reasonable relation to the fee, it's legal.
Okay, we have a motion that's on the table. You've heard any other discussion on the amendment that's been offered? Commissioner Moon has offered an amendment to make that $8,500 deposit, in fact, a fee. Of course, the resolution as it's drafted, as you see, pays back any unexpended balance as a part of the application process. His amendment would make that a flat fee that would be charged. You've heard the recommendation of council. Any other discussion? Let's see, the next item, next person up is Commissioner Romano on the amendment.
Okay, yeah, I'll take an amendment one too.
Go ahead.
That $8,500 flat fee is, none of it's going to go back to the person who took the permit out.
That's his amendment.
That's, okay. I'm disillusioned here. There are so many people asking questions about it. This is the first time I've seen it, but I will take a recommendation from our planning commission. And I realize how much time they do spend in it, and I want growth to pay for itself. But during this 6 months, what happens when this 6 months up? You come to a plan?
No, let's stay on the amendment.
Okay.
Please, on the amendment. Anybody wishing to speak, I'll come back to you, Commissioner Romano, if you could. Let's move. Let's see, Commissioner Brockman on the amendment?
No, I've already spoken.
Commissioner Walton on the amendment?
No, sir. But I do have a point of order. Do we have a second on the amendment?
Yes. Commissioner Hancock made the second. Let's see who's up still. Number 2, Mr. Chalfont? Nothing on. Who would like to address the amendment? Let me clear, let's see here. Lou?
No, none on the amendment.
Okay. Anybody want to discuss the amendment? Commissioner Davis.
Thank you, Mr. Chairman. As much as I agree with Commissioner Moon on making growth pay for itself, I think we're going against our own legal advice with the amendment, and we don't charge for every other service that we do through planning, and therefore we might create a legal problem that we don't have with the resolution as it stands today. So I'm not sure we ought to go forward with the amendment unless and until we go through the Planning Commission and all the proper committees on that. Thank you.
Thank you. Any other discussion on the amendment? I see no discussion, no request for discussion on the amendment. 110424 amended. The amendment is to make this a $8,500 flat fee. If you're in favor of that amendment, press the yes button. Opposed, your no button. Has everybody voted that wishes to vote? Record the vote, please.
5 yes, 2 abstain, 16 no.
5 yes, 2 abstain, 16 no, so the amendment fails. We're back to the original motion, 110424 as on the floor. And if we could, let's get everybody cleared here and let's start over. Okay, if you want to speak, punch your button. Commissioner Romano.
Back to my question for Mr. Sanders. When this comes to the end, 6 months, what happens with this deposit and the planning from there?
Well, the money that was talked about for deposit, if someone were to come in for an application during this process time, during this interim time, then that application at the adoption of new ordinance, that's what the interim is for. If we decide to go forward with this ordinance, then that means that we're going to be working through the public hearing process for changing just one section of our zoning ordinance regarding telecommunications facilities. And we will iron out all of the nuts and bolts of how Williamson County wants that ordinance done during that interim time. In the meantime, an applicant can come in, they can do the same things that we require now, plus what we anticipate to be some added requirements. But that site plan, that's that application process, putting together their site plan, putting together their radio frequency charts and their propagation studies, and finding their search rings for their locations of their sites. And that that process, that's the reason why this process gets to continue on in that relationship. So, because just like I was saying, some of these people I've been working with since April or May on the same tower sites that they have yet to get those in. And we've got those processes that they could continue with during that period of time. It's just that once we adopt a new ordinance, then it will finalize just exactly what Williamson County wants for their permanent zoning ordinance regarding telecommunication facilities.
Will the people that were here that spoke tonight be in on the meetings, or will they just be at a public hearing that can be?
They
heard?
are,
How's that gonna work?
of course, any of the public hearings are, and if the Planning Commission decides to put together a subcommittee to work on this, this ordinance, which is the normal route of working up a zoning ordinance amendment, and these people are contacted. They've known about this meeting. That they, tend to show up at the public hearing at the last minute. And I offer to you that it's harder to run this train than it is to just get up and say whoa to it. But they are invited to come and have input, and we would welcome that, and there would be a place for that. There would be public hearings held for the zoning ordinance amendment, which is standard operating procedure at the Planning Commission.
So you're telling me within the last months from March, when you said you thought you needed to do something, some of these people have known about this, because several of them got up there and said they only knew in the last couple weeks, and I only knew since I got my packet. So it's been kind of known.
Yes.
Do you anticipate them getting back any of the $8,500 if they apply for one in the next 6 months?
Yes, I'd say that there's a big difference in the amount of time that would need to be spent for a new tower site and a co-location site. And this interim makes no differentiation between those two. A permanent ordinance will make a different amount if we go continue with that route, which, in other words, a co-location would require less submittal of money or escrow account up front. It would be what I've been looking at for the future. But yes, I've been told that an average site, that an average cost of one of these runs $2,500 to $5,000 for the review cost, depending on the site involved.
Okay.
Mayor Anderson? Mayor Anderson?
Yes, sir.
Public hearing is over.
Mr. Chairman, let me make a suggestion. I know a lot of you got discussions, and the comments are correct, and I want to echo Tom's and Mary's comments too. We're trying to find ways in government, as all of you know, to not always take it out of the coffers that we have, and that's what this is all about. I might make a suggestion for those individuals if they're out of Alabama or wherever, but I'm sure the local representatives put together a subcommittee and let them work simultaneously during this 6-month period. If it's that much interest tonight, and it has been before the Planning Commission, then put a committee together, 5, put Lee on there as a committee, get one of the county commissioners and 3 of these individuals out here that live here in our community, that have an opportunity to make discussion, just like we did on the highway issue about 2 years ago, which Ernie and Clyde, many of you on, that we looked at the road issue. We've looked at many things, whether it's comprehensive steering committee that you and Judy are upon now, and some of these other committees we've done, that let these individuals who feel like that there's some input or they're not getting input, we'll give them that opportunity during this interim period. And I know the one gentleman there, I don't remember his name when I was in the back, offered to help in any way. I believe he was with Verizon. Gentleman in a gray suit. Take him from the right. Yes, you. I'm with Singular. Excuse me. But if
when you said Verizon, he said, "Can you hear me now?"
Put them both on it, Mr. Chairman. If he wants to come up here from Alabama every meeting, that's fine. But we'll put a committee together and work through this thing simultaneously. It's a terrible situation you're in, but they have to realize too, you have a fiduciary responsibility to act upon the taxpayers and the dollars. And I know all of you are concerned about it, and John's exactly right. There's money on the table. That's what it's all about, ladies and gentlemen. So if they would serve on a committee, get a motion, put 5, we'll put 1 staff, 1 of you county commissioner, 3 of them, we'll give them a chance to load it up and bring it back to you. We've been very effective with that method.
Mr. Mayor, clarify what you're saying, though, is based on your recommendation, this resolution needs to pass in its form and have this go on concurrent with the implementation of this interim application.
Mr. Chairman, this is an interim. This is all this is. It's an opportunity. I know that Mr. Ridley, is that the way you pronounce his name? Ridley came to the office last week. We've made available to him all the contracts, all the information, what we're attempting to do. I know this is a last-minute effort that some of these men and women probably haven't seen, but it has been an ongoing process for several months. And I offer them the last minute here to let's get on a committee and let's see what we can do. But we do need to take some action because Lee has got several applications there.
I see.
And for you that have followed what has been occurring, we had one just recently that came before the Highway Board. It's a little different in nature, but it was the same thing upon Linwood Way, a very, very tall tower that the Highway Board turned it down because of the fall radius. And that was not with any of these individuals that I know about. But we do see these, and we need some help on these. And if you would allow us this opportunity, or we've got to get some additional manpower and woman power to help us get through some of these regs.
Thank you, Mayor. Commissioner Chalfant.
Just a point of clarification here. One of the, within the communications, someone mentioned that the Center for Municipal Solutions was not recorded or not filed with the Secretary of State's office. Are we running into a problem? They're not licensed to do business in Tennessee if they're not filed with the Secretary of State.
Counsel.
If they don't have an office or a place of business in Tennessee, I don't think there is a requirement. We could run into, although it's included in the contract since I drafted the contract, that if there was a dispute, jurisdiction here and we use Tennessee law. Other than that, I'm really not sure. That's a kind of blindsided me and I'd have to look at it. But if there was a problem, then I would go back and either terminate the contract. It would have nothing to do with what we're doing right here, right now, at this moment.
In my current employ, it's my understanding that regardless of where a particular company is, and this is in the could be well within the telecommunications area. If they're not registered with the Secretary of State's office, then they are not permitted to do business within the state.
Well, I'm not even sure whether they're registered or not. I would have to look at it if you would like.
I would appreciate that because
sure.
that I think is
Lee, do you have any?
That may be a moot point, or that may be a point that we need to consider before we go
Thank you,
too much further anyway.
Mr. Monroe stated that they have filed for that license with the Secretary of State.
Thank you. Okay, Commissioner Green.
Now, Lee, I may ask a question of Lee, please?
Sanders, would you approach the podium, please?
Yes. In our conversation this afternoon...
Would you stay at the podium, please?
Okay. In our conversation this afternoon, you talked about propagation, RF.
Yes.
RF propagation. When, at the end of this 6 months, are we going to have somebody trained on staff that understands RF propagation?
No, sir. That's the whole purpose of this. The employees of the Center for Municipal Solutions have that training. I've had to, over the past 10 years, 8 years, learn at least those words. And I know that that's involved in the decision-making process on where they locate these facilities. And I have decided that if I was going to get into the radio frequency business, that I was going to have to go back to school and probably have to leave my good county job, and I decided not to do that. And that's the reason why we do need some some help in those matters. And that's what this would provide for us.
Thank you.
Thank you, Commissioner Green. Stay close, if you would, Lee. Commissioner Walton.
Thank you, Mr. Chairman. On one of the references on the back of this handout that they sent us, I happen to know the mayor of one of these towns and talked to him, and he put me through to the gentleman on the back. He said that since they've had, first thing he said, they used to be known as Monroe Telecom, and about 6 months ago, so Lee said he talked to him in March, they changed the name to the Center for Municipal Solutions. They were real pleased with them, but he said that to make sure our attorney went over what they did, because their proposals are, as in his words, were a canned proposal. In this particular state, they were having trouble with reinforcing it because it wasn't applicable to those state laws. So through the chair, I don't know if the attorney's done that, but he said he said they liked what they were doing, but they were having trouble with enforcement.
Any comment on that to council?
Sure. Mr. Chairman, one of the aspects of that we will be going through, one of the processes that they will be working closely with our office to ensure that we can enforce this under Tennessee law and under the FCC. What they have provided you is just a very general regulation that will be molded into what our needs are, okay? Once those needs are defined and we mold this regulation, our office will go over it and make sure that it does comply with both the Tennessee law and the FCC.
Follow up, Commissioner Walton?
No, sir.
Commissioner Williams?
Call for the question.
Second.
Commissioner Williams, second. We have a second call for the question. All in favor of the call of the question, say aye.
Aye.
Opposed? The ayes have it, so the question has been called. So Resolution 110424 is loaded on the machine. If you're in favor of this resolution as it's presented, press your yes button. Opposed, your no button. Has everybody voted that wishes to vote? Record the vote, please.
16 yes, 3 abstain, 4 no.
16 yes, 3 abstention, and 4 no. So the resolution as presented is adopted. Okay. Anybody want a break? Let's take a 10-minute recess. As discussion ensued over the break, as we have passed Resolution 110424, it's fairly good consensus of the Commission that we need to listen carefully to the input. The comment was made in discussing with the mayor that he would like to ask that this body appoint a commissioner to serve. Commissioner Clyde Lynch has agreed to serve working with the mayor to work with representatives of these companies over the next few months to address this interim application. And what I would like to do is ask on behalf of the commission and give direction to the mayor that these people that do participate in this process be residents of Williamson County, that they actually live in the county, and that they be allowed to do that. So, Commissioner Hancock, are you prepared to make that motion?
I make so move, Mr. Chairman.
Motion is made by Commissioner Hancock that we appoint Commissioner Clyde Lynch, who is our Budget Committee Chairman and also can represent well the thoughts of this body in working with the mayor and the mayor will appoint 2 or 3 people, probably 5 in total, that are the business people to work with him to bring this back and work through these regulations. Is that appropriate, Mayor? Is that what you need? Okay, any discussion on the motion? Commissioner Hayes.
I certainly recommend Clyde doing that. I guess in our district, it's one of the districts that I guess would be most populated with these towers. I've been in this room many times where there would be a room full of citizens who were in opposition to a cell tower coming. And we've needed some regulations to help guide that. By the same token, we need to be fair to the property rights of the landowner, because in many times it is the possibility of them getting some income that is equal or greater than perhaps their Social Security or other benefits they might be getting. So we certainly need to look at all those avenues. It concerns me that we have been populated with so many towers, but still there are some dead places in the county, and I think that's one thing that we're all looking. It's also of interest that many people do not realize how much everyone counts on their cell phones, and what makes the cell phones possible, of course, are the use of these towers. But I do believe there's more opportunity for us to be creative. In our comprehensive land planning, we're looking at protecting the view shed and preserving our land and our view, and that's something I'd like for us to continue to do. There are many things now, innovative things that are being looked at. There's the monopole and the lattice tower. There are trees that are towers, although right now the only one I've seen that looks like a tree would work if you were in Colorado with an aspen tree, because I think an aspen tree might stick out here. I haven't seen a maple or an oak, but perhaps there's one. I do know that there are cell towers that look like flagpoles. We have one on 96 East, very attractive. I know in several situations, cell towers are put in steeples of churches, and they're put also on towers. The factory has a cell tower on their water tower. There are very innovative things that can be done, and I would hope this committee would look for that. Another thing that had concerned me, and I was prepared to certainly totally endorse this resolution, but before I did, I wanted to for sure find out that it did not affect the amateur radio ham operators, because they offer a great emergency service to our country and our community. Perhaps you don't know that on 9/11, there were approximately 4 to 6 hours in New York where every line of communication was shut down except for the ham operating amateur radio operators. They protected life, they protected property. So that's something we certainly don't want to interfere with, and I was assured by our attorney that this resolution did not have any effect on those situations at all. I think there's a place for us to commingle here, and I think that we do need to do more of what we've started doing, limiting heights, making them cohabulate on or have mingle on the towers to cooperate with that. And I think that there are a lot of things that we can do to make this work for everybody. But I do endorse the committee. I don't think it should be structured by just one group, but I think the mayor certainly could put it together, and I think Clyde could certainly represent our district.
And Commissioner, if I could, to make sure that this study group coordinates with you and Commissioner Brockman in your comprehensive study work so that we gain the momentum of that. And also, from the chair, I'd like to officially ask our council to develop a written opinion justifying or at least documenting the fee issue and the latitude that we have in establishing a fee issue, if in fact it can be a set fee or whatever. So if you would, Bobby, develop that and furnish that to the chair, and we'll go forward with that. Commissioner Bivens, you're next.
Thank you, Mr. Chairman. I just wanted to state, again, although this is not directly related to the resolution, I think out of an abundance of caution, I need to abstain on this vote as well. I just want to point out, I certainly think Commissioner Lynch will be an excellent representative of this body, but out of an abundance of caution because of the conflict before, I feel like I need to abstain on this vote.
And also show for the record that he abstained earlier on that vote, clearly in the record, and there's also the clear conflict of interest abstention that's here that the Commissioner has requested. Any other discussion on this motion? Commissioner Hancock?
Yes, Mr. Chairman, is this dialogue, and I'm certainly in favor of this, as this dialogue proceeds along, I would hope that there's a lot of issues, there's a lot of different agencies, as I travel about in the county, that have these dead spots that Commissioner Hayes was referring to. I would like every opportunity to, for multiple use or piggybacking or those kind of things, so that this truly could be a win-win for everyone concerned. There's a lot of areas out there that are dead for a lot of different agencies.
And just as a point of information, as the sheriff continues to suffer with our people that are out defending us in the morning, there are parts of the county that they're absolutely out of contact with any radio or communication countywide, so that is an issue. Any other discussion? I see none. All in favor of the motion, say aye.
Aye.
Opposed? Shall Commissioner Bivens abstaining, conflict of interest. Thank you very much. So Mayor will proceed along with that process. 11, let's see, where are we here?